What if a company has already been dissolved and legally ceased to exist, but later a hidden asset is discovered, a creditor emerges with an unpaid claim, a fraud comes to light, or a major legal mistake is uncovered? Is the story over forever? Or can the law actually bring a dissolved company back into existence? Most professionals believe that dissolution is the absolute end of a company. However, corporate law contains a powerful safeguard that can reverse what appears to be the final legal closure of a company. A misunderstanding of this provision can expose directors, liquidators, creditors, investors, and professionals to serious legal and financial consequences. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are discussing Section 302 of the Companies Act 2013, one of the most fascinating provisions in corporate law, dealing with the power of the tribunal to declare the dissolution of a company void. To appreciate the importance of this provision, we must first understand the relationship between winding up, dissolution, and restoration of legal existence. In the normal course, a company is incorporated, conducts business, complies with various laws, may eventually enter winding up, and finally gets dissolved under the provisions of law. Dissolution is generally regarded as the legal death of a company. Once dissolved, the company ceases to exist as a separate legal person. However, lawmakers recognized that exceptional situations may arise after dissolution. A previously unknown asset may be discovered. A liability may remain unresolved. A creditor may establish that its claim was overlooked. Evidence of fraud may emerge. Litigation may remain unfinished. Property belonging to the company may come to light after dissolution. If the law had no corrective mechanism, stakeholders could suffer significant injustice. Section 302 was enacted to address precisely such situations. The legislative intent behind this provision is to ensure that dissolution does not become a shield for injustice, fraud, mistake, or procedural irregularity. The provision protects the interests of creditors, contributories, shareholders, and other affected stakeholders. It gives the tribunal authority to revisit a dissolution order when circumstances justify intervention. The section provides that where a company has been dissolved, the tribunal may, on an application made by the company liquidator or any other person who appears to the tribunal to be interested, make an order declaring the dissolution to have been void. This is an extremely significant judicial power. The expression any other person interested is deliberately broad. It enables stakeholders with a genuine legal interest to approach the tribunal. A creditor may apply, a shareholder may apply, a contributory may apply, a person having rights in property belonging to the dissolved company may apply. The tribunal examines whether circumstances justify setting aside the dissolution. The law does not permit reopening merely because someone changes their mind. There must be a legitimate legal basis. The tribunal exercises judicial discretion. This ensures that the power is used responsibly and only when justice demands intervention. An important feature of Section 302 is the time limit prescribed under the provision. The application seeking declaration that the dissolution is void must generally be made within 2 years from the date of dissolution. This time limit is extremely important from a compliance and litigation perspective. Professionals advising stakeholders must carefully monitor limitation periods. Failure to act within the prescribed period may adversely affect legal remedies. When the tribunal declares the dissolution void, the legal effect is profound. The company is treated as if it had not been dissolved. For practical purposes, the corporate existence is revived to the extent necessary to deal with pending matters. This enables unresolved affairs to be properly addressed. A useful example can help explain the provision. Imagine a company undergoing liquidation. The liquidator completes the process. The tribunal orders dissolution. Several months later, it is discovered that the company owned valuable immovable property that was never disclosed during liquidation. If the dissolution remains untouched, stakeholders may lose substantial value. An interested party may approach the tribunal under Section 302. The tribunal may declare the dissolution void and allow the affairs relating to that property to be properly dealt with. Consider another example. A creditor discovers after dissolution that its legitimate claim was omitted from the winding up process. Without a remedy, the creditor may suffer significant prejudice. Section 302 gives an opportunity to seek judicial intervention. Now consider a governance-related situation. Suppose investigations reveal that material information was intentionally concealed during liquidation. Suppose fraudulent transactions were hidden from stakeholders. Suppose assets were diverted before dissolution. The tribunal may examine whether the dissolution should be declared void to facilitate proper administration of justice. This illustrates why Section 302 serves as an anti-abuse mechanism within the corporate framework. The provision reinforces transparency, accountability, and fairness. It reminds stakeholders that dissolution is not necessarily immune from judicial review. From the perspective of creditors, the section is extremely important. Creditors often rely on liquidation proceedings to recover outstanding dues. If material facts emerge after dissolution, Section 302 offers a potential avenue for legal relief. From the perspective of shareholders and contributories, the provision protects economic interests that may otherwise be lost because of incomplete or defective winding up proceedings. Directors should also understand the governance implications. Although dissolution may mark the end of the company, it does not necessarily erase scrutiny relating to past conduct if serious issues later emerge. Proper record keeping, accurate disclosures, and transparent liquidation processes remain critical. Company secretaries play an important role in ensuring that statutory records, corporate documents, and governance records are properly maintained throughout the life cycle of the company. Chartered accountants assist in verification of financial information, realization of assets, and closure-related financial reporting. Cost accountants may assist wherever cost and financial analysis become relevant. Advocates represent stakeholders before the tribunal and advise on litigation strategy. Section 302 therefore demonstrates how multiple professionals contribute to effective corporate governance. A practical secretarial perspective reveals several compliance lessons. Maintain complete records throughout liquidation. Ensure accurate asset identification. Verify creditor claims carefully. Document stakeholder communications. Preserve tribunal orders and liquidation reports. Review unresolved litigation before seeking dissolution. Many post-dissolution disputes arise because these precautions were neglected. Students preparing for professional examinations should remember the distinction between dissolution and declaration of dissolution as void. Dissolution ordinarily ends legal existence. Section 302 creates a statutory exception allowing the tribunal to intervene in appropriate circumstances. This distinction frequently appears in examination questions and practical case studies. Another important concept involves judicial discretion. The tribunal does not automatically grant every application. The applicant must demonstrate sufficient grounds. Evidence becomes crucial. Supporting documentation often determines the success or failure of the application. A common practical mistake is assuming that dissolution permanently closes all possible legal issues. Section 302 demonstrates that corporate law recognizes exceptional circumstances requiring corrective action. Another mistake is delaying action after discovering relevant facts. Since limitation considerations are important, prompt legal advice is often essential. From a due diligence perspective, professionals involved in mergers, acquisitions, restructuring, and litigation reviews should carefully examine whether any dissolved entities may have unresolved assets, liabilities, or legal proceedings. The existence of Section 302 means that dissolution may not always represent the final chapter where significant legal issues remain unresolved. The provision also supports investor confidence in the corporate legal framework. Stakeholders are more likely to trust a system that contains mechanisms for correcting mistakes and addressing injustice. From a governance standpoint, Section 302 reinforces the principle that corporate closure must be fair, transparent, and complete. From a litigation standpoint, it provides a remedy where dissolution would otherwise create unfair outcomes. From a compliance standpoint, it encourages careful liquidation practices and accurate documentation. Ultimately, Section 302 acts as a powerful safety valve within the winding up framework of the Companies Act 2013. It recognizes that despite best efforts, mistakes, omissions, hidden assets, undisclosed liabilities, and unforeseen circumstances may sometimes emerge after dissolution. Rather than allowing injustice to prevail, the law empowers the tribunal to intervene and restore legal existence where necessary. For company secretaries, chartered accountants, cost accountants, advocates, insolvency professionals, directors, and governance practitioners, understanding Section 302 is essential because it demonstrates that dissolution is not always the end of the legal story. It is a reminder that transparency matters, records matter, stakeholder protection matters, and corporate governance continues to influence outcomes even after a company appears to have disappeared from the legal landscape. That is why Section 302 remains one of the most important protective provisions in the winding up framework of the Companies Act 2013. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.